Good afternoon and welcome to the Fifth Step Europe virtual panel discussion. Today the topic is the EU succession regulation. My name is Alberto Pérez Cedillo. I am a Spanish lawyer and English solicitor practicing between Madrid and London, and I'm president of STEP Spain. Before we start, I have been asked to remind you of a few housekeeping items. Basically, STEP is in control of the platform, so we will need not to worry about our microphones as they have been muted, and the question and ask function will still on. I doubt very much we will have time because we have a very tight schedule, but please, if you have any question, pass them to the platform as they will be taken into account for future seminars. The good news is that we will be recording this session and it will be available to watch on demand from tomorrow. You will receive an email with the link to the recording. I will also like to thank IQ-EQ for sponsoring this seminar. Let's begin. It is a real pleasure to have with me today Richard Frimstone. Is Richard here with us? Hi, Richard. I think you're in mute now.
Yeah, hi.
Fantastic. Hello, Richard. Richard is very well known by most of us. He's a consultant with Russell Cook, where he was a partner from 1982 and head of private client unit until 2018. He has a particular expertise in dealing with multi-jurisdictional states, especially with France. He's a member of STEP, Council, and of the Law E Society, the EU Committee, and as well as very other distinguished professional bodies. Richard is a very prolific writer. He has co-edited The International Protection of Adults for Oxford University Press and commentaries on the EU succession regulation and the EU regulation on matrimonial and partnership property regimes. Thank you for agreeing to be here with us, Richard. And I will be making you questions which I am sure they will pose no difficulty for you.
Thank you very much for inviting me. It's great to take part.
Okay, I noticed that in one of your excellent books, Richard, the EU succession regulation, you comment that every time you look at the regulation, you learn something new. I'm sure it happens to quite a few of us too. Has the regulation, in your opinion, simplified the rules in all cases?
It's difficult, isn't it? Because it was meant to. I think it's a bit like intestacy. It's a good thing for ordinary folk with not many assets. But I think people with complex lives who've done a lot of planning, it has introduced uncertainty. As we'll discuss later on, for example, the private international law position in Spain was quite clear. And some practitioners in Spain find the succession regulation puzzling and difficult. So change is always difficult, and trying to get the private international law of the whole of the EU harmonized on every aspect of succession is really very difficult. So it is a work in progress. It will be subject to review again in 2025, and I'm sure there'll be some tweaks. There will continue to be lots of Court of Justice decisions, I'm sure, every year. So we'll see more and more developments. So I don't think it's simpler. I think it's more interesting.
It's a more interesting intellectual exercise. Well, let's hope that the interpretation of the European Court of Justice is uniform and doesn't complicate things a bit even. But I agree that it's a work in progress and has to be followed very, very carefully.
Yeah.
But on that very point, do you agree that basic terms like, for example, member state have to be approached when we read the regulation in different ways throughout the regulation? If we take into account that we have to take into account the two non-participating countries, Ireland and Denmark.
I I mean, we had a long debate about what member state means in the regulation, particularly when the UK in the good old days used to be a member state. I think there's no question that the Commission intended that member state in the regulation does not include Ireland and Denmark. I don't think Parliament particularly thought about it, but I suspect that if it had, it would have agreed. And I'm sure Council of Ministers would agree. So I think the likelihood is that if the issue ever came to the Court of Justice, it's likely to say that that member state does not include Ireland or Denmark for any purposes at all.
I will agree with that comment, but let's hope that when they clarify, they go along your idea. The fact is that the UK is no longer an EU member state, but do you think that will have a direct effect on the working of the regulation?
I mean, I think that's one of the only advantages of the UK not opting into the succession regulation in the first place, is that Brexit and the UK leaving the EU has not had a single jot of an effect on the working of the EU succession regulation. I mean, it's interesting, isn't it, that the regulation as part of EU acquis is still part of UK legislation. If you go to UK legislation, the EU succession regulation is there, even though the UK is not bound by it and it is not affected by it directly. But of course, its indirect effects continue in exactly the same way as they did before.
And they will do in the long run. I should think it will be very difficult to keep it completely isolated in that sense.
Well, of course, when Scotland becomes independent and joins the EU, I'm sure that the EU, with any new member state, will insist that the succession regulation is binding. So I look forward to the days when Scotland is subject to the succession regulation.
Things are not going to get any easier, aren't they, Richard? Or any simpler. Right. Going back to that, yes, sometimes when you look at the regulation, you realize that it requires a succession with cross-border implications in order to be applicable. However, I think there is no definition of what the European legislator meant by cross-border implications. What should we look for an answer? Where we can find what he wanted to mean by this?
I mean, it slightly comes out of Article 2, which says that the regulation shall not affect the competence of the authorities of member states to deal with matters of succession. So it is by implication saying that the regulation only applies in a cross-border situation. In the case of EE, is really helpful on lots of different issues, particularly habitual residence, which we can talk about later on. But I think in terms of cross-border, the jury is still slightly out, in that clearly in EE, where the deceased was habitually resident in Germany but had assets in Lithuania, you clearly had a cross-border issue, because if you've got the deceased habitually resident in one place and assets in another place, you certainly have a cross-border estate. But I do wonder whether just the existence of an heir in another state actually creates a cross-border succession. If all the assets and the deceased are in Germany, the fact that one child is living in Austria, does that make it a cross-border succession? I'm not sure that it does. Why would there need to be a European certificate of succession? You can see that if there were arguments about clawback or some requirement to enforce an order of the German courts in Austria, then it becomes cross-border. But if there's no dispute, is it definitely a cross-border succession? I'm not sure that it is.
Yes, I think we're going to have to wait for more outcomes from the European Court of Justice. But it is true that sometimes it might look like subject to the regulation at a certain stage, and then another stage it might not be, which is peculiar. But going back to the habitual residency, we all know that that basically regulation has to apply across all the different legal systems and languages, and therefore has created these autonomous terms, which are very important, and we have to take into account that they are independent in their own accord, and they belong to the regulation in a way. No, they are not necessary, or they don't have the meaning that they will have in individual jurisdictions. But of course, the most difficult to grasp sometimes is habitual residency, which is an autonomous term, and it gets quite confusing when you realize that this term is used in other regulations, but that you cannot really take the meaning in the other regulations to be applied to the succession regulation. And there are issues there that look very confusing. For example, in your view, can there be, for example, more than one habitual residency? Is that possible?
I mean, you're right that language is one of the primary problems in the world. So the Tower of Babel has a lot to answer for, but also I think the regulation didn't help when its language versions used terms that were already in existence in the local jurisdiction. So, for example, an agreement as to succession, in the German version, it's got the same word as an inheritance contract under German law, and the things are different. So using the same word doesn't actually always help. Habitual residence, of course, is a connecting factor in all sorts of different ways. It's a connecting factor for Hague Conventions. It's a connecting factor locally. And some people feel that habitual residence for the purposes of EU regulations ought to have the same meaning, that it's wrong that it has different meanings in different regulations. But there's no question that habitual residence for the purposes of the succession regulation must be a tighter, more connected, a stronger factor than it may be for other regulations. So it has a different meaning for succession purposes than it does for Brussels II purposes, for example. The case of EE, the Advocate General's opinion, is really useful in going through what habitual residence means and the aspects that should be looked at to work out habitual residence. And the Court of Justice in EE very clearly agreed that for the purpose of the succession regulation, you can't have more than one habitual residence. I mean, there has been some criticism of that, in that in a European Union with the freedoms that European citizens have to move themselves and capital and all the other things, there is an argument to say, why should a European citizen only be entitled to have one habitual residence? And I think the answer, of course, is that habitual residence is an artificial connecting factor to link you to one particular system. I think the more difficult question is, why does the succession regulation not enable citizens a broader choice of the applicable law that they would wish to attach to? Why can't EU citizens attach themselves to a former habitual residence, for example? And that, of course, is a cultural and political issue that many states who used to have the connecting factor of nationality really didn't want to see multiple, such freedom, such autonomy for EU citizens to choose their own applicable succession law. But I think that's the question that will be coming up in 2025, is whether just the choice of nationality is sufficient to enable citizens to exercise their rights and freedoms under the treaties. I don't know. What do you think, Alberto?
I think it's very peculiar, yes, that they give you the freedom to move, but then they don't give you the freedom to choose. So it is peculiar from that point of view. I agree. But then
And
again,
that's discriminatory, isn't it? I mean, if I'm disabled in some way and I can't move to Spain, whereas if I was fully able and I could move to Spain, then I could change my applicable succession law. So it's discriminating against me.
it is, no, I completely agree. But it's also the peculiar situation that the provisions that you made while habitually resident in one place will be valid if you change your residency. So the whole thing is quite complicated, no? Because you can play that game of making the necessary arrangements at the correct time and then get away with more or less what you wanted if you were habitually resident there.
Yeah.
That is a fact in the European legislation, that you always need a very capable lawyer, I think, Richard, which is good for us. But that's the common citizen trying to sort things out is, I think, it's another completely different deal, no?
Yeah, yeah.
And talking about that, the fact that the regulation grants a certain degree of autonomy to the disease and to the heirs, in fact, to opt for different applicable law or a different jurisdiction, respectively. As you were saying, that the freedom is nonetheless limited, because the deceased can only choose the law of the state of his nationality, and the heirs can only opt for the courts of a member state whose law has been chosen by the deceased. What about the choice in itself? How you view the fact that that choice might be an implicit, can be an implicit choice or a deemed choice?
Absolutely. So that is perhaps one of the difficult aspects, that if there's a specific choice, everybody knows where they are, but actually many documents may be an implied choice. And we had the recent decision from the German Supreme Court finding that
very surprising. It was fascinating.
The handwritten contract between a married couple, one of whom was German and one of whom was Austrian, made in the 1990s, was an implied choice of German law, and that even though the contract didn't have binding effects under Austrian law, the implied choice of German law meant that under the succession regulation, that historic implied choice was valid in Austria from 2015 by virtue of the succession regulation. And I think that's the right conclusion. What's more difficult, of course, is the historic deemed choice under Article 83.4, which is if you've made any old will under the law of your nationality, even though it only relates to part of your succession, that is to be a historic deemed choice. And that's something that so many people still don't know about and don't know that they've made that choice.
True.
Obviously, the choice for Article 22, the choice of a professio juris for your succession law, will affect the substantive validity and admissibility of your disposition of property upon death under Article 24, 25. You can actually choose a different law for that purpose. So if you've got two nationalities, you can choose one law for one and another law for the other. But for the heirs to be able to choose a jurisdiction under Article 5, obviously the deceased must have made an Article 22 choice.
Absolutely.
And the heirs can't make an implicit choice of jurisdiction. They have to make a direct binding declaration that they want jurisdiction to move to the place of the applicable succession law.
Yes, the situation with the beneficiaries is quite fascinating. They say that everything is okay if the beneficiaries agree. Then it's a regulation that gives you quite a lot of freedom. The problem is if they don't, which very often is the case.
It's usually when we're involved.
Yes, absolutely. But also when the choice of law has also the problem of the regional legislations and the variety of systems that basically are applied not only in Europe, but in other parts of the world, like federal states. No? So basically, in multi-territorial or interpersonal legal systems, the choices of law can be very, very dangerous.
And difficult and uncertain, can't they? I mean, it is this issue that if you've got a state with multiple systems, you're looking at Article 36, and the question is whether that state has its own rules to decide which of its multiple jurisdictions applies or not. And of course, the UK, the US don't have federal rules, they just have local rules. So you then have to go to the part of the UK, the part of the US with which you are most closely connected. And that can be quite difficult and dangerous to establish, particularly if jurisdiction is with a Spanish court or something, and it's going to be the Spanish court that decides which part of the UK or the US the deceased was most closely connected with.
Yeah, and expensive, with basically providing affidavits of foreign law, and exactly, so it's a very lengthy procedure and quite expensive. And as you said, well, in Spain, that is a fact. For example, we have different legislation in different autonomous communities.
Yep.
So the thing can get quite complicated when people even choose a Spanish law. But one thing that it seems at the beginning that was an advantage of the regulation is that it was abolishing, once when the professor juris, the choice of law will abolish renvoi, at least between member states. But however, the situation is different, is the law applicable is that of a third country, and that is when it's vital to do this choice of law, or at least will give, you know, if not absolute certainty, a degree of certainty, you know. So sometimes basically the choice of law should be considered as the only alternative if you want things to work out in the long term. Yes,
I mean, I'm in favor of being very clear as in your will. Are you making a choice of law, or are you not making a choice of law? And actually saying, if there's any risk of it being a cross-border succession, then specifically set out in your will, are you making a choice of law or are you not? And saying so. I mean, obviously we do have problems in that renvoi is something which everybody groans whenever you mention it.
It is.
And said, oh my God, it's too difficult. And of course, renvoi always looks different depending on where you're standing, and whether you're standing in the shoes of a Spanish court or you're standing in the shoes of an English court. And of course, you have this problem that many practitioners still haven't quite taken on board the broad reach of the succession regulation and the effects that it's had, and that whereas under previous Spanish PIL, generally renvoi was not accepted, now it ought to be, and not everybody's caught up with that.
No, you may encounter a lot of difficulties, and there are still a lot of registrars that if they have to deal with immovable property, they will question the renvoi and say that basically, you know, the principle of unity is paramount, and they will only apply one single piece of legislation to the succession. So the renvoi will be compromised. I think it's difficult, the renvoi, to understand, particularly when you realize that there is quite a lot of uncertainty depending on the law of the country and the decision that they would take on that particular issue.
And it's a doctrine which comes in and out of favor. So in English law, although it clearly does affect inheritance law, there are many aspects within the scope of the succession regulation where under English PIL there is no renvoi. So administration of the estate, for example, I don't think anybody can argue that English PIL would say that there is renvoi in relation to administration. They just say it's a matter for the local jurisdiction to apply its own administration law. It's not within the jurisdiction of the English court. So renvoi doesn't apply under English PIL to all aspects of the succession regulation, only to some aspects of it. And that too is not always easy to remember.
No, but I am with you that it's vital to exercise and to basically be very clear about your choice of law. And if there is a third state involved, then you have to be extremely careful and to look into the private laws of that state in connection with the connection they might have for the renvoi. But it's funny also, I think, Richard, that there is the succession regulation that has been heavily criticized, and everybody sort of like going around the succession regulation, but that at a local level, we find the figures of the notaries, which in the jurisdictions are operating. There have been recent court cases like the WV and EE, and they all seem to agree that it's not very often that they will be considered courts. And from that point of view, they seem not to be sort of like subject to the jurisdictions, no, set up by the regulation. And is this sort of like phenomenon of the jurisdictionalization of the situation with basically succession, where notary publics operating outside the boundaries are producing and operating and sorting many of the problems. What are your views on this phenomenon?
De-jurisdictionalization is a great word, isn't it? I'm told that it was invented in Italy first. So Giovanni, when he comes on in, can tell us what it really is in Italian.
Yes, it's difficult enough to pronounce it. So
absolutely. I mean, I think certainly it was one of the concerns of the UK Ministry of Justice in the negotiations on the succession regulation, was the fact that notaries might be outside the jurisdictional rules, and certainly some of the decisions of the Court of Justice, particularly emanating from Polish notaries, some of whom are good mates of mine. I think the decisions of the Court of Justice was very much based on evidence from the ministries of justice rather than from notaries. So I'm not sure that all notaries would agree with the decision of the Court of Justice. I think that from a practical point of view, some notaries thought that it was a great victory that they weren't subject to the jurisdictional rules. And I'm not so sure. De-jurisdictionalization will be reviewed in 2025. The European Law Institute's got a project going on this very issue, and there may be some suggestions as to tweaks to the succession regulation to deal with the issue. But from a practical point of view, of course, notaries' problem is that the effect of their notarial certificates are bound up with their local jurisdiction. So if you've got a notary from Lithuania produces a notarial certificate, it will have the effects that Lithuanian law give to it. And that's not necessarily that certain. Whereas the European Certificate of Succession, under Chapter 6 of the regulation, it's very clear as to what its effects throughout the European Union are.
Absolutely, yes.
So from a practical point of view, if you've got a cross-border succession, although technically a local notary might be able to produce a certificate, why bother? Why not just get a European certificate? Much easier. You know what its effects are in your state. You don't have to get evidence as to what the effects of the local certificate are. So I'm not sure that in practice it's going to be that far reaching. I can see that in old circumstances, I don't know what your experience is between Spain and Portugal, for example. I don't know whether notaries understand each other's certificates and might be happy to swap certificates. So I can see that at boundaries, old ways of doing things might continue for a while. But in the European Union, where everybody's moving around a lot, I think the European certificate will be the one that wins through.
Right, yes, we will see. That's a battle to be fight, I think. One last question for you, Richard, in connection with the regulation and the future. What is your view on the future of the regulation, and it is well equipped to deal with, for example, digital assets?
I mean, digital assets are really interesting. There's lots of people worrying about it. The European Law Institute's got a project on it. And I think one of the problems is, what is a digital asset? Is it actually an asset, or what you have is merely access to something? Where is the asset? What do you need to do? I would have thought regulation is as well placed as anybody else. If you've got a European certificate of succession, that may help you. But of course, one of the problems with digital assets is that the chances are you're dealing with the law in Ireland or in California, neither of which are subject to the succession regulation. We shall see.
Back again to the issue of member states.
Yeah.
Hi, Carolyn. Thank you very much, Richard.
No, thank you. That was really interesting.
Pleasure. Thank you very much, Richard.
Thanks a lot.
Right. Our next speaker is Giovanni Cristofaro. Giovanni is a partner and head of Chiomenti's Wealth Management Business Unit and advises both Italian and international clients on matters concerning planning, management, and use of family assets, including company shareholdings and artworks, with a focus on family wealth planning, including domestic and cross-border successions, intra-family wealth transfers, and trusts. He's a member of the Executive Committee of Estate Italy. Giovanni, please, when you're ready.
Thank you, Alberto. Happy to be part of this panel. And thank you to Richard for his very interesting speech. Well, the regulation is in these days, in these months, is of a great application in Italy in relation to the well planning of individuals, even though we do not have so much court cases dealing with the regulation. We have a couple of court cases interesting to discuss, and but we do not have so much cases. Also because, as per Italian law, regulation raises a couple of main issues relating to the important mandatory rules of Italian succession system, in particular reserve shares and succession agreements. Such issues were in different ways addressed in our previous succession system, because before EU regulation, Italian private international law is a law dated in 1995, did not mention, for example, succession agreements, and moreover, protected Italian resident legitimate heirs and their reserved shares in the context of succession governed by foreign laws. In particular, the mechanism provided by our previous private international law was completely the opposite of the one provided by the EU regulation now. Article 46 of the Italian private international law provided that the succession is governed by the national law of the deceased at the moment of the death. And the deceased can select the law of the state of his residence by will, provided that, of course, he resided in this state at the moment of the death. So you can see that the mechanism is completely the opposite of the one provided by the regulation. in addition to such provision, as per Italian law, in case of the death of an Italian citizen, such choice, such professio juris, cannot prejudice all rights reserved to legitimate heirs residing in Italy at the moment of the death. Now, you can see that after EU regulation, succession agreements are regulated and mentioned in the EU regulation, and the protection of legitimate heirs and the protection of reserved shares no longer exist, even though, of course, some references are mentioned in the regulation, in particular in relation to the administration of the estate. We know that the regulation aims to determine a single law governing the entire succession on the basis of the habitual residence. So such mandatory rules must be governed and verified case by case, of course, in the light of the new provision of the EU regulation. As per the residence criteria, that is the new criteria also for Italian law system. The residence criteria now under the EU regulation is the main criteria, whilst in the previous Italian succession system was the exceptional criteria. And you know that as per habitual residence, as already mentioned by Richard, we have some criteria in the regulation, in particular under the whereas 23, 24, and 25, where the assessment of the habitual residence must take into account the circumstance of the life during the years preceding the death and at the time of the death, and also other requirements must be taken into account as relevant factual elements, duration, regularity, condition and reasons of the residence. And the regulation itself provides that in certain cases, determining the deceased habitual residence may prove complex. And we have one interesting case issued by a court of the south of Italy, the court of Salerno, in 2019. The proceeding is still pending, so we have not evidence of the conclusion. But in this case, the court dealt with the habitual residence issue in relation to the division of the estate of an Italian citizen died with no will. All heirs were Italian national resident, and similarly to the famous case of Johnny Halliday, the Italian court decided to investigate better the features of the habitual residence of the deceased, making an in-depth analysis of all facts. And the court found that the deceased died in New York. He married in New York in 1989, whilst he died 70 years after. His wife resided in New York. He had his main familiar and working interest in New York, and in addition, he had given a general power of attorney in favor of one of his brothers for the management and administration of his assets in Italy. So, implying in the view of the court, so implying that Italy was not more under his control. So the judge decided to suspend the proceeding for the purpose of acquiring or checking the US laws and regulation on succession, and then decide on the applicable law. Interesting in this case is that the jurisdiction the Italian jurisdiction was confirmed as with the Italian court in the light of Article 4 of the regulation. So Italy is a member state of habitual residence. In this case, no member state, of course, of habitual residence, since New York is not part of the regulation. Article 10, so the jurisdiction is with the member state where the inheritance assets are located in case the deceased were national of that member state, in this case, Italy. As per the reserve shares, as mentioned before, the EU regulation, says that the law governing the entire succession of a deceased shall be the law in which the deceased had his habitual residence at the time of the death. The EU regulation provides, of course, exceptions to such a rule. And this exception is mentioned by Article 35 of the EU regulation. Article 35 provides that the application of this rule may be prevented in case it does not comply with the public policy rules of the relevant member state. So in case, as per the regulation, the governing law of succession does not protect reserve shares, maybe Article 35 can be used for prevent the application of the regulation in the light of the prejudice for the reserve shares. It is interesting to note from our side, from Italian side, that there are two different notions of public order in the regulation, a broader one and a more detailed one. The first one, the broader one, is the internal public order. The restricted one is the international public order. Article 35 literally makes reference to the internal public order. So in case of a governing law that does not protect reserve shares as provided by the Italian law, what we have to do is the investigation if reserve shares principle falls under the internal public policy or not. In such respect, we can say that Italian law provisions concerning the reserve shares cannot be qualified as public policy provisions. In fact, the Italian Supreme Court also recently has clarified that the Italian Constitution does not include any reference to the reserve shares. Therefore, Italian provisions concerning such shares cannot be considered as public policy rules. So the violation, a governing law that violates or does not protect reserve shares under Italian law cannot be considered prevented by the application of Article 35 of the regulation. At the end, we had, as mentioned by Richard before, a recent judgment issued by Italian Supreme Court in February 2021 about the renvoi back or reference back under the Italian private international law. Such case applies also to the can be considered as applied also to the in the light of the EU regulation 650. As per the Supreme Court case, in this case, the complaining party was an Italian citizen married to an English citizen domiciled and deceased in the United Kingdom. Before the marriage, the deceased made a will in the United Kingdom, appointing children as his heirs and assigning to the spouse a legacy only. the spouse submitted an action for petition of inheritance before the Court of Milan and requested principally to ascertain that the testator's will had been revoked by his subsequent marriage in accordance with an English law provision, the Article 18 of the Wills Act of 1837. So in this decision, the Supreme Court clarified that the applicable legal framework in this case can be found in the Italian private international law. And in the present case, the national law of the testator will therefore be the English law. And the English, the English private international law splits the rules applicable to a succession, subjecting movable property to the law of the deceased domicile and immovable property to the lex recite, with a consequent reference back to Italian law. Therefore, the principle of the reference back admitted under the Italian international private law makes the affirmed principle of the unity of the succession set out in our system. So at the end, the Supreme Court acknowledged that from the point of view of the law governing the international succession, the simultaneous principle, the simultaneous presence of the rule of the unitary and universal nature of the succession and the rule of the renvoi impose on the judge the task of carrying out of a not easy coordination. It follows that given this simultaneous presence, two successions are opened and two inheritance assets are formed, each subject to a different law, in the light of which the court has to verify the validity of the title of succession, the identification of heirs, and the determination of shares, and the protection of legitimate heirs. Thank you. I think.
Thank you very much, Giovanni. Always fascinating what will happen with European regulation and public policy. The European Court of Justice has not pronounced itself. Let's see what one day we'll have to do it.
Yeah.
Thank you very much, Giovanni. And now our final speakers today, who are Jean-Charles Gardetto and Lori Dimitrov. Jean-Charles is a member of the board of STEP Monaco and the former president of the Bar Association. He handles both advice and litigation for private clients and corporate entities. His main practice areas include civil law, family law, business law, banking, contracts, international private law, immigration, and white-collar crime. He was an MP from February 2003 to February 2013. Lori was admitted to the Paris Bar in 2012 and practiced as an attorney in France for over 6 years. She has published legal doctrine in family law and international European family law, and she is the co-author of a book of private international law. She also is a regular speaker at various conferences on those matters. So, Jean-Charles, Lori, whenever you're ready.
Thank you very much, Alberto. Thank you very much for having us with you today. We're very happy to be part of this webinar. I'm going to talk briefly about the jurisdiction issues and the conflicts of laws issue. And Lori is going to talk more specifically about forced heirship rules and trusts. What we will do is a comparison between the EU succession regulation and the law on private international law that we had here in Monaco, which we call the Code of International Private Law. So as you all know, Monaco is not a member of the EU, therefore the EU succession regulation is not applicable in Monaco. we have what we call the Code of International Private Law, which entered into force in July 2017. We have very little case law about this new statute, so it's a little bit challenging. But the inspiration comes from international convention, mainly Hague Conventions, and also the EU regulations, which have suggested certain positions of the lawmakers. Our law is pretty short. It's an 11-page piece of legislation, while the EU succession regulation is rather substantial, since it is a 30-page document. So we have, as I was briefly saying, many loopholes, many unclear provisions, and that leaves a lot of room for interpretation by the courts. So we expect to see what the courts here in Monaco are going to decide. We're still at the very beginning of this process, and there's not been so much litigation about this piece of legislation. So what are the rules which are included in the code regarding succession matters? The main ground for jurisdiction in succession matters is close to the ground retained in the EU succession regulation. But while the EU regulation retains the criteria of the last habitual residence, here in Monaco, we retain the criteria of the place where the succession has been opened. So Monaco is competent if the succession was opened in Monaco. If that means if the last domicile of the deceased was here in Monaco. So I have to say a few words about the concept of domicile, because that changes depending on the jurisdiction. In England, the domicile is not the same. We consider the domicile as it is defined in the Code of International Law as the principal establishment. Monaco also attracts many foreigners, so we have a special provision which is a presumption of domicile for foreigners. We consider that if a foreigner has a residence permit here in Monaco, he's presumed to have his domicile in the principality. This is a presumption which is rebuttable in case of multiple residences, or if the domicile is disputed. It is then essential to take into consideration the elements and all the elements which concern the personal, social, and professional life of the person who dies here in Monaco. There is really no definition of the principal establishment, and we have to take into consideration two elements to analyze that concept. The first element is a material element, that is a certain stability and continuity, with an assessment of the duration or the effective presence in the principality. And the second element is an intentional element. We want to see if there is a will of the interested party to establish his or her residence, the center of his patrimonial, emotional, and social interests here in the principality. There is also other differences regarding the approach that we have compared to the EU regulation, because in the EU regulation, the last habitual residence rule is a priority rule of jurisdiction, and it's only when the deceased did not have his last habitual residence in a member state that one can rely on an alternate ground for jurisdiction. If no member state has jurisdiction, then there are rules which are subsidiary rules, or the forum necessitatis, which is under Article 11. While here in Monaco, under our Code of International Private Law, the rule is the last domicile. And I mean, that is an additional ground for jurisdiction, as it supplements the general rule, which is the domicile of the defendant. So it comes in complement to that general rule. It needs to be combined with two other grounds for jurisdiction. The first one is the location of real property in Monaco. And the second ground is the Monegasque nationality of one of the parties. There is no priority between those various grounds for jurisdiction. So what are the rules of conflict of laws in succession matters under our Code of International Private Law? Well, the rule is that a single law governs the whole estate, whether the assets are movable or immovable, whether the assets are based in Monaco or located in another country. And in principle, we apply the law of the deceased last domicile. But we do recognize the possibility of a choice of law, the professio juris. It must be expressly stated, while I understand that under the EU regulation it can be implicit. Well, here it has to be very explicit. It has to be in a will, and it has to be in favor of the testator's national law. It cannot be for any kind of law. The choice is limited. But if the deceased has several nationalities, then it is possible to choose between either of them. So there is a certain number of options if you have several nationalities. We have the same approach than the EU regulation, except that we are more focused on the domicile rather than the habitual residence. And also an important difference regards the forced heirship rights. And then I'm going to give the floor to Laurie, who is going to deal with this issue of forced heirship rights. Thank you very much.
And so the issue of forced heirship rights, or the reserve portion, is really a point where the Monegasque Code of Private International Law took an original approach, different than the one used in the succession regulation. In the succession regulation, and the Italian colleague pointed it out, this issue is resolved in each country under Article 35 of the regulation, whether or not each country considers that forced heirship rights belong to their public policy or their notion of international public policy. So in Italy, I understand from our Italian colleague that Italian courts consider that it did not belong to public policy in an international context. In France, in 2017, the French Court of Cassation considered that it did not either, unless exceptional circumstances where the heirs were left in need. Well, in Monaco, we retained a different approach. There is a specific provision in our code relating to the law applicable to forced heirship rights. So, as Jean-Charles pointed out, the law applicable to the succession is the law of the last domicile of the deceased, if there is no choice of law for the national law. But our code provides that, however, the law applicable to the succession can neither deprive an heir of forced heirship rights guaranteed to him by the law of the state of which the deceased was a national at the time of his death, nor apply forced heirship rights to the succession of a person whose national law at the time of his death does not have that regime. So it means that even if the deceased did not choose his national law to govern his succession, in which case his succession is governed by the law of his last domicile, his national law will nevertheless apply in any case to determine the existence of forced heirship rights. The rationale behind that rule is that in Monaco, in accordance with its own legal culture and tradition, wants to apply forced heirship rights to the succession of Monegasque nationals, but also wants to respect the legal culture of the many foreigners living in the Principality and the philosophy of transmission specific to each country. There are several difficulties that arise from this original approach. The first one is what happens if the deceased had several nationalities and one or some of his national laws does not provide for forced heirship rights, but others do. That's an open question. there is a provision in our code relating to the most effective nationality, the one that has the closest ties with the DC, with a person, but it's not provision that is specific to succession matters. So we don't know if that's going to be used to resolve that issue. Another difficulty, another open question is, what if the deceased chose one of his national laws in his will to govern his succession, and that law does not provide for forced heirship rights, but the law of one of his other nationalities, especially the law of his most effective nationality, provides for such forced heirship rights? Will that law take precedence, the chosen law or the most effective law? Another difficulty, when there was no choice of law, that is to say, when the law applicable to the succession is the law of the last domicile, how broad is the interference of the national law with respect to forced heirship rights? In other words, should the deceased national law govern only the principle of the existence of forced heirship rights, or should the national law also govern the scope and the modalities of calculation of the reserved share, even if the law of the last domicile protects forced heirship rights? We tend to favor the first interpretation in the light of the spirit and the letter of Article 63, but this remains an open question as well. And the issue has major implications, because obviously the reserved share may not be the same under the national law and the law of the domicile, and also the modalities of clawback may be different. As some law considers that the clawback only applies to any lifetime gifts. Under other laws, it's within the 10 years of the death, so it has great impacts. And one last word, I don't know if I still have time, but it's regarding trusts, because in Monaco we recognize trusts. We have a specific law regarding to trusts, and we have provisions in our Code of Private International Law. So basically, we need to combine trusts with inheritance matters and forced heirship rights matters, and basically you're going to be able to choose the law applicable to your trust, and the validity of your trust and the way it functions will be governed by that law. But regarding succession matters and whether or not you can go around forced heirship rights, you will need to look at the law applicable to the estate, and regarding forced heirship rights, the national law, as I explained, to determine whether these assets will be left outside the scope of the estate and of forced heirship rights or not. And this has been clearly stated in the explanatory statements of the draft bill that gave rise to our Code of Private International Law. They use the example of an English trust and succession governed by Monegasque law, and they said that these assets should be within the bulk of the assets for the purpose of computing forced heirship rights in that case.
Thank you very much, Laurie and Jean-Charles, and also thank you very much for the other speakers of today, Richard and Giovanni. And thank you very much to all the attendees. I hope you found this very condensed webinar as useful and suggestive as I did. We have the next step Europe virtual panel discussion that takes place on Thursday, 13th of May, and will cover international protection of adults. You have a chance to see and learn from Richard again. The recorded webinar will be sent by email tomorrow with a direct link. And please complete the evaluation form. It's always good to know what else you would like us to arrange and to plan our future events. And thank you very much once again to our sponsors, IKEQ, for their full support. Thank you very much. Goodbye.